This High Court case can be tricky. The facts are simple enough. The plaintiff worked in a steel mill. He regularly had to walk across oily coils of steel to pull down a bar which would secure them for the next part of the process. He slipped on the oily surface and he was injured. Soon after this incident, the company upgraded some of its equipment, and one of the upgrades was a new hydraulic bar which could secure the coils without the need for anyone to walk across them. All of this was complete before the case went to trial, and the plaintiff, the man who was injured, led evidence of the upgrades. His purpose in doing so was to prove to the jury, there was a civil jury in this case, that it was practicable to avoid the risk of harm from manually lowering the bar, and the company itself had proved this by implementing a new system. The company, strangely, led no evidence at all during the trial, none whatsoever. Nothing about what the cost was, or whether the accident actually led to the new system, or whether the hydraulic bar could have been installed separately to the major plant upgrade. Because they did none of those things, the High Court agreed that it had been appropriate to allow the jury to consider the upgrade when they decided if the company had met its duty of care. However, Acting Chief Justice McTiernan dissented. He noted that there had never been a similar accident previously. He argued that the fact that the company did implement changes doesn't necessarily lead to the conclusion that they had a duty to make those changes. He said that even if the previous manual process of lowering the bar was not as safe as the mechanised system adopted afterwards, this is not a sufficient reason in itself to entitle the jury to find the company guilty of negligence. The Parliament has since agreed. Section 10C of the Civil Liability Act says the subsequent taking of action that would, had the action been taken earlier, have avoided a risk of harm does not of itself give rise to or affect liability in relation to the risk. This makes sense. After an injury, even just a pure accident, we want companies to investigate and improve things. The law protects them when they do so.